welcome everyone. Let's see if you hear me and we'll get started. Let's see. All right, God bless. And let me say hello to everyone who's come in and happy Thursday to you. We'll say hello to everyone and then we'll get started. And for some reason, I can't find my audio controls here. I'm a little mystified. Oh, there they are. Okay. All right, so let's see. I'm going to back it on up. Hey, everybody. A lot of people in here early. All right, so let's see what we got going on. We got Heather Brown, first one in. Hello, Heather. Heather Brown, Snoopa Loompa. You can still call me Snoop. Okay. Dom S. Dino, I won't touch that. And yes, Nicole. What's up, Deb? Artist formerly known. Heavy Metal Rehab. Dom S. Digital. Sweet Dude Shibby. Mark Ellis. Hey, Mark Ellis. Where you been? Good. I'm glad you're here. Good. You're okay. Okay. Good to see you. Digital. Mino Dino. Tracy Fleetwood. Hey, Diana. Diana's here. Court of Public Opinion. What's up, Court of Public Opinion? All right, boom. Carla Ann. Hello. What's up, Carla Ann? Boom, boom, boom. Who else is here? Hmm. Amy. Hey, Amy. What's up, Amy? All right. Noe's here. What's up, Noe? What's up, Mino Dino? Amy. Court of Public Opinion. Sweet Dude Shibby. Nicole Watt. Hello. We got Tracy Fleetwood. Amy G. Hey, welcome back, Amy. All right, Mandy Gillian. What's up, Mandy? All right, thank you for supporting the channel, whether through likes, comments, donations, or memberships. Thank you, Amy. And hey, Carla Ann, thank you for saying hello to everyone. All right, boom, boom, boom. You guys are having a good day in the chat. What's up, Digital? Uh, Amy G. Mark Ellis. Heather, I had to have an operation on my foot. Oh no, Mark. We knew you were dipped out for some reason. All right, what's up, Snoompa Loompa, Nicole Watt, Tracy Fleetwood, Diana, um, Noe, Amy, Heather Brown, Deb. All right, you guys are just chatting it up early. Who else we got in here? Four Pits. What's up, Four Pits? Four Pits in here. Dieter. Hey, Dieter. What's up, Dieter? Dieter, where are you? I don't see you in here. I'm trying to do something fancy. There you go. All right, we got Mino Dino, Heather Brown, Mandy, Amy G, Kate U. What's up, Kate U? What's up, Kate U? What's up, Kurt with an X? Okay, who else we got in here? Four Pits, Heather Brown, Heavy Metal, Samantha Springman. What up, Samantha? Nicole Watt, Mino Dino, Dumbass. You got unsubscribed. Well, how in the world you work that out? Rebecca Ann, 1965. What's up, Rebecca? Four Pit says share, share. Please do. Tonight will be important. Okay, when we get to the legal discussion a little bit, tonight will be an important one. What's up, Cotton Candy? Look at the cute puppy. It's a wiener dog. All right. What's up, y'all? What's up? What's up? Four Pit says like, subscribe, share. Please do. Boom. Shakalaka. What up? Says it's a new day. What up? It's a new day. Driving. So limited till chat later. Well, get your butt home and chat. All right. All right, y'all. New Day, what up, New Day? What up, Dirty Diana? What's up, artist formerly known, Rebecca Ann? Hey, Rhonda Holton. What's up, Rhonda? Rhonda and Stephanie. What's up, Stephanie? All right. It's a new day, member for 9 months. Thank you. Thank you. All right. Hope your foot heals well. Yeah, that's a good idea, Four Pits. Well wishes for Mark's foot. Hope your foot heals, Mark. All right. What's up, Christina? Right. Hey, Swade Smith. Hi, y'all. Prof, 100% thank you for coming on. Yeah, we got a little talking to do. We'll do a little talking. Okay. Diana, Stephanie, Samantha. It's a new day. What up? What up says, thank you for all you do and endure, Prof. Thank you for the super chat, super sticker, whatever that happens to be. That's a super chat, right? Necessary. What's up? What up, Jake Brooks? Jake Brooks, coming on in. All right. Trial Junkie. What up, Trial Junkie? Hello to you. Hello. All right. Boom. Co-op, digital. Okay, necessary. What's up? So I think I got everybody. So welcome in, everybody. Glad to see you. If you're on the replay, go ahead and hit that like anyway and leave some comments. Leave the comments down below. Trust me, this will be an informative show for you, this thing that we're about to do. But we're going to start off with some other chit chat. What's up, LB? Okay, what's up to you? All right. Right. So let's see what else I got to do here. Uh, hmm. Hmm. All right. I'm getting lost. Okay. All right, Joe. Oh, you were in the little channel? Yeah, heads up, everybody. There are two channels. The big channel is called the Prof. Come on over here if you want the chat. The little channel is called the Prof True Crime. That's going to be true crime exclusive as we expand. But go ahead and make sure you're in the big chat if you want to be in the big chat. Sorry about that. Fair warning, okay? Now, hey, I want to talk about something, okay? A few things. So, Karen Reed, right? Karen Reed was acquitted. Wow. So I had some thought about that. All right, I had some thoughts about that, and how would I, how would I get into this? Let's see. I thought a lot about this Karen Reed acquittal, okay, and I thought, what are the similarities? Okay, what are similarities? And very first thing that came to my mind were those cops fucked around. You know, the cops. Uh, you see, they tried to pull a fast one. You see, and then I thought about same with Delphi. Okay, and that's interesting because I thought about that and I thought, wow, what would I say? You know, what would I say? And I had a few points that came to mind, and I thought that it'd be good for us to talk about. Um, and the first is I thought about my suspicion of her guilt or innocence compared to Richard Allen's, my suspicion of Richard Allen's potential guilt or innocence in factual. And and I thought, wow, you know what's funny to me? Um, that jury actually did the right thing as opposed to Richard Allen's jury. And I compared that in my mind and I thought, wow, because you know the funny thing that I must admit to you, what I got to admit is I think that Karen Reed is more likely guilty of what she was accused of than Rick Allen. Okay, let me be 100% with you. If I would do the odds on the two, what are the odds of her guilt or innocence? What are the odds of his guilt or innocence? I got to admit that I think being what I know about the situation, which is not anything, other than an observer, I would say I would say that in my mind, she's more likely to be guilty of what she was accused of than Richard Allen. And I thought about that, and I thought, wow, isn't that weird then? That she was acquitted when she was more likely to be guilty of what she was charged of. And Richard Allen was convicted when he is less likely than she is to be guilty of what he was accused of. And I thought that was a very interesting observation. Then I started thinking about the bad side of that. And I would say the bad side of that, and tonight may be a little rough ride for you people, listeners who live in Indiana, because my ultimate conclusion comes down to ignorance. And I thought, wow, I thought, you know, this really is telling about the people of Indiana, the plague or the problems that plague the state in the general level of intelligence or ignorance or lack thereof, or whatever you want to call it. And I thought, wow, it just really does show that the people of Indiana, they have problems that they have to deal with. And it got me thinking about this too. In my opinion, you see, all of us, we're the helpers. Okay, we're the helpers. You and me who don't live or are not residents of Indiana, we're the helpers here. We're the observers. We're the helpers. The problem is this fight, the real fight here, belongs to the people of Indiana, because you have a problem plaguing your state, your society, and you are the only ones who can fix that problem. It's your elected officials, okay? It's holding your police departments accountable, your governor, your, on down accountable. And I also thought about the legal teams. And I thought, wow, this is something. Because, listen, it's very clear that Karen Reed's defense team were world-class professionals, okay, on a world stage. And that's really, it's really clear just watching them, even from a distance, because, I didn't follow this second trial very closely. But let me say, following from a distance, watching from a distance, it's clear to me that these attorneys behind Karen Reed were world-class professionals, serious heavy hitters. And they knew they were acting on a world stage, okay? Now you compare that with Richard Allen's defense team. And hey, I'm not here to judge. I'm not here to cast stones, cast aspersion, or anything like that on Andy Baldwin and the team. But let me just say, there's no comparison, okay? I think there's no comparison. It's an entire league of their own over there in Karen Reed's case. And so if you truly do reflect on both the defendants, the juries, the law enforcement, and the defense teams, and you sort of cross-reference all those with these two cases, it really is indicative more than anything of the general state of demise and corruption in Indiana. Okay, because sure, I'm sure there is plenty systemic corruption in Canton County and other counties. That's not really the question. We're doing an A-B comparison. In comparing all that we saw there with all that we saw with Richard Allen, it really is, it's no comparison between the two. Because in Karen Reed's case, it functioned as it should, okay? The jury functioned as they should, the defense functioned as they should, and the entire thing functioned as it should. And it's only reasonable and fair at the outcome we see. And if we compare that, like I said, to Richard Allen's case in Indiana, uh, there's no comparison because it's the exact opposite in Richard Allen's case. You had a horrible jury who made terrible decisions, very little critical thinking. Just check that with the jury of Karen Reed. And then I think when you back off of that and look at that whole picture, more than anything, uh, I guess what's the term? It's an impeachment upon the state of Indiana. Okay? And so, yeah, uh, I think that that's all I have to say about that. You see, you may remember that I covered Karen's first trial, and there was a reason that I didn't cover it this time because I didn't want to. I already had seen enough, I had heard enough. I didn't want to do it all over again. And so, honestly, I also intended to cover the verdict, uh, and I just couldn't bring myself to do it. So I think, if anything, I may do a coverage later once everything settles, once all the dust settles. But I just could not, I must admit, I couldn't even get in to handle it one more time. So that's going to be it for me. For now, that's going to be my comments on it. So that's your fill. Now I got another fill. You're going to enjoy this one. Okay. In Delphi news, it's been a somewhat, you know, mundane week, so to speak. But there's something. Okay, there's something here. Let's see. So I want to show you guys something. You may know the official representative for the Patty family, Frank Shyster. Okay, so so there was this show the other day. As you see, there's a show on June 5th here. June 5th, right? 2025. The Meister Crew Noe Done FAFO. Okay. So I'd like to bring something to your attention because this is the person who portrays himself as the official spokesperson for the Patty family, and I found a very interesting thing here that I had missed before, and I want to bring this to your attention because unfortunately somehow I managed to miss this uh, when I covered. Remember, I did cover that Frank Meister has been issuing the threats of a hit on Richard Allen. So on behalf of the Patty family, Frank Meister has been relaying that there's a hit. There was a hit on Richard Allen. There's a hit on Richard Allen. Okay, and that he deserves every bit of the karma that he gets. Is I believe what I've displayed to you last time. But there's another quotation I wanted to bring to your attention from the Frank Meister, and here it is. He said, I did a live and said that Becky had hired me to get Richard Allen killed. I blew a gasket and she just started laughing. And she said, in other words, Becky Patty, I understood what you said, but she said, I don't want him killed. I just want him to suffer a little while. I'm like, oh. So again, according to Frank Meister, Becky Patty said, I don't want him killed just yet. I want him to suffer a little while. So imagine that right here, Frank Meister, official spokesperson, unofficial spokesperson for the Patty family, says, I talked to Becky and she said, I don't want him killed just yet. I want him to suffer a little while. I don't want him killed just yet. I want him to suffer a little while. Okay? So that's your messaging from the official spokesperson, unofficially for the Patty family, Frank Meister. Um, but as you can see, that's that's the 30-minute mark, 30-minute mark at the June 5th, 2025 True Crime Talk. Okay. So in case you wondered, Becky Patty doesn't want him killed just yet. Okay. She preferred that he suffer a while. So as if he hasn't suffered enough. All right, so that catches us up on the news for the week. And with that being said, I would like to um, briefly get into, or shortly get into our presentation for the evening. But please give me a moment because I feel that I need to take care of something. So just give me a moment and I'll be right back. All right. Thank you for waiting. Thank you for that. It took a little bit. All right. So next up, all right. Welcome to everyone who comes in. Okay. Let's see. Next up, what are we going to do? I'm going to do this. Let's see. All right. All right, guys. So there's an announcement I have to make. I have decided to enter a new phase, so to speak, in terms of making better use of my posting. And I thought about this a bit, and um, and I decided that what I wanted to do is create a Substack. Okay, so I'm going to invite everyone to go over to subscribe to my Substack. I just put it down in the chat. It's also in the description and in the channel description. So if you'd like to find my Substack, it's very easy. It's called Read the Prof. Okay, Read the Prof. So if you go at Read the Prof at Substack, you'll find me easily. And the way that's going to work is It's primarily going to be a subscription-based service. So if you go over there now and you want to see everything that I do, 100% of what I do, just subscribe over there, and it's a paid service. I will do about, say, 1 out of 5 posts I will make public. So if you're just interested in a periodic update over there, you're going to see that you can still do free subscriptions, but with the free subscriptions, there's no comments and there's no 100% of everything that I do. So primarily over there, it's a place for paid subscribers to follow me very closely. And the interesting thing that I'm going to be doing is I decided I'd rather make this a one-stop shop, a be-all, do-all, okay? So instead of just posting about Delphi like I might do on this channel periodically, I'm going to post about everything that I want to. So I'm going to be making lots of posts, several a week is my intention, to be very active over there, uh, writing my thoughts, presenting my thoughts, all kind of different aspects, not just on Delphi. Okay, so if you follow me over there, you can join the community over there. And like I said, you can also follow for free if you prefer to do that, and you'll just catch the major updates. But I did the first one, and I made it free for everyone so that everyone can see it. And I'm going to read this first one for you to give you an idea. This is an important message anyway that I feel needs to be shared. And to be honest, um, this resulted from some conversations that have been happening behind the scenes. Okay, so I don't know how closely I want to reveal this or how much of this, but myself and some friends, including some who you may be familiar with, and maybe some who you're not, who you're not. We have been discussing some pressing things, especially in regards to the past couple months, the things that have been happening and the discussions that have been going on, and some of the things that have not been not so good behind the scenes. And we got to talking, and as a result of a bunch of those conversations and some talking with a bunch of friends, I determined that this would be the best route, to utilize Substack for what it's really good at, which is presenting ideas and forming a community. And over there, we can be without the distractions of YouTube drama and of true crime in general and chaos and all this stuff. What we can do is more efficiently talk about the things we want to talk about. And I can give you a lot of my ideas on a variety of things. This is going to be a cross-cultural thing, not just, like I said, on the Delphi case of true crime. So I want to read this for you though, because this right here is my first posting there, and it's covering something that's very important to me. Okay, and so I want to talk about it before we get into our show tonight. I want to read this for you, and especially for those of you who can't read, or with bad vision, or you'd rather listen. This is a great resource. Okay, so I'll read it for you. You don't have to read it. So I called this Protecting the Process, Moving Forward with Care, Clarity, and Community. As this case moves into its next chapter, many of us are taking time to reflect on how we got here and where we're going. For those who followed Richard Allen's case closely, it's natural to feel a deep investment in the outcome and a desire to stay engaged. That commitment is powerful, and it speaks to a community that genuinely cares. But it's also a moment that calls for caution, compassion, and careful thought. Right now, we're in the post-conviction phase, waiting to see if the appeal will be granted. It's important to understand what this really means. Winning an appeal doesn't mean Rick goes home immediately. That was never going to happen, no matter who might have led you to believe it. In reality, however, It could mean that he might be granted a new trial, a clean slate, where the defense will have a chance to present the evidence, testimony, and explanations that were previously barred, withheld, or underdeveloped. And that's where this moment becomes so important. Appeals are not about introducing new facts or theories. They focus on whether legal mistakes were made in the original trial, errors that may have violated a defendant's rights or resulted in an unfair outcome. That work is being handled by professionals with deep expertise in the law. If a new trial is granted, the next stage will absolutely require clarity, facts, and strategy. Which is why what we do now matters so much. Many of us remember how quiet things were in the lead up to the first trial. Yes, there was a gag order, but there was also strategic intention behind much of the silence. Rick and Kathy didn't testify, and because of that, there are still important parts of their story that the public and the prosecution don't fully know. That's not by accident. It was a decision made to protect their rights and preserve the opportunity to tell that story when it would matter most. Let's not forget that once Rick had legal representation, law enforcement could no longer continue to question him. And while the prosecution may have worked through thousands of pages of discovery, they might have missed things. Things which could become key points of contention later. That kind of detail may end up being incredibly valuable in the hands of the defense at a later point. So here's where community awareness becomes essential. We don't want to reveal the defense's strategy too soon. Talking openly about Rick and Kathy's movements, thoughts, or intentions might feel like defending him. But it could also unintentionally give the prosecution a head start in preparing for their response. In a retrial, surprises don't come out of nowhere. They're built slowly and carefully through legal channels. If we broadcast those building blocks too early, we risk giving away one of the few advantages the defense still holds, the element of timing. This isn't about fear or gatekeeping, it's about foresight. And this isn't about silencing advocates. It's about protecting the integrity of the case. There's something else to consider: witnesses. Please, for your own sake and for the integrity of the process, do not contact or speak publicly about witnesses, ever. Even casual public discussions can unintentionally affect their testimony or perceptions. Worse, anyone speaking too openly about new sensitive details could potentially become a witness themselves. That's a heavy burden, and it's one that most people never intend to take on. Now, none of this is said to shame or criticize. In fact, it's the opposite. This community is full of people who care deeply. Many of you have followed this case with intensity, compassion, and the hope of seeing truth and justice prevail. That is a gift. But like any gift, it needs direction. And right now, the best direction is inward. It's patience, it's contemplation, it's protection, it's restraint. So what can we do? We can continue to support Rick and Kathy by respecting their privacy, by treating their story with the same care we did before the first trial, and by doing what we each do best. We can be mindful about what we post or share. We can utilize our talents without the need to be anything and everything to this case. We can avoid speculation and stick to the facts. And if we're moved to take action, we can channel that energy into education, advocacy, or even quiet encouragement. There will come a time when more needs to be said, when voices will be needed to challenge, clarify, and confront new evidence, new things. But until that time comes, holding space is just as powerful as loudly speaking out. Prayer, just as powerful as fight. Let's walk this next stretch with empathy, empathy, clarity, and a shared commitment to doing what truly helps. Let's protect this process, not just for Rick, but for everyone who deserves a fair and just outcome, including Abby and Libby. We're still walking together, and every thoughtful step counts. The appeal now follows structured steps, briefs, possibly oral argument, and judicial review, focused entirely on legal issues, not a retrial or any new evidence. That will be saved for post conviction relief. In essence, the period following a criminal conviction is crucial for preserving a defendant's legal rights, particularly when considering the possibility of an appeal. In Indiana, where Richard Allen was convicted and sentenced, this post conviction phase requires careful attention to deadlines and legal procedures to ensure a fair process. An appeal in Indiana involves submitting written briefs outlining alleged legal errors made during the trial. The Court of Appeals reviews the trial record not to retry the case, but to ensure legal standards were upheld. The court may affirm the conviction, reverse it, or remand it for further proceedings, which would be a retrial. If unsuccessful, a defendant may seek review by the Indiana Supreme Court, although such review is discretionary. This process protects defendants' constitutional rights, ensuring that mistakes or violations do not go uncorrected. However, high-profile cases like Allen's attract significant public attention and media attention, which can sometimes interfere with justice. The involvement of podcasters, internet sleuths, and the general public in contacting witnesses, victims' families, or gathering their own tips can jeopardize the fairness of any current or future trials. Such interference can intimidate or traumatize witnesses, contaminate evidence, and bias potential jurors, undermining the defendant's right to a fair trial and potentially leading to mistrial or reversal. Additionally, public speculation and harassment can cause irreparable harm to the victims' families and the accused alike. Despite these risks, the public can still engage responsibly with true crime cases. Responsible engagement includes following vetted and official sources, discussing cases without harassment, interference, or speculation, supporting systemic justice reform, and respecting the privacy and dignity of all involved. For advocates, content creators, and citizen journalists, especially those producing true crime media, ethical guidelines are essential. They should respect the presumption of innocence, avoid contacting parties involved, verify information rigorously, use trauma-sensitive language, and moderate their communities to prevent harassment or the spreading of misinformation. The post-conviction period is a delicate and critical phase, requiring careful legal management to uphold justice. Public interest and participation in true crime cases can be positive when conducted with respect and responsibility, but unchecked interference risks highly damaging the legal process and potentially the lives of those involved. Upholding ethical standards benefits everyone and preserves the fundamental fairness that should be at the heart of the criminal justice system. The justice system relies on neutrality and due process, not on public opinion. However, people can absolutely be engaged, and our voices can have a direct impact on the greater good. Respect fact over narratives, use empathy, not speculation, speak from logic, not emotion, and support reform, not chaos. Kara Weinecke states, I would anticipate that each side, Allen and the state, will request and receive at least 90 days each for briefing. So 6 months from early July, and when adding the reply briefing time, takes the case to early 2026. The Court of Appeals, if it does not set oral arguments on the case, takes on average 3 months to decide a case. I'd assume we're looking at closer to 6 months because everything the parties review, the court will need to review as well. That puts us at mid 2026 before we receive a decision. The party that loses will seek transfer to the Indiana Supreme Court. If you don't ask for extensions, and parties rarely do, that's still 75 days from the Court of Appeals decision for briefing. That puts the case into late 2026. The Supreme Court, assuming it does not grant transfer, it does not set oral argument, is still going to need several weeks, 5 to 6, to decide whether to take the case. Richard Allen cannot file his petition for post-conviction relief and get on the state public defender's 2-year wait list until the Supreme Court declines or grants and decides the case. And if he decides to file a petition for writ of cert to the U.S. Supreme Court, the post-conviction petition must wait even longer. What does all this mean? Best case scenario, Allen finishes the direct appeal process in late 2026, probably December. Even if he immediately files a petition for post-conviction relief, his case will not be ripe for review until mid to late 2028. It's not unreasonable for post-conviction investigation to take years to complete before a hearing is held, especially when the case is this complex. Okay, so I hope that all of you heard the bulk of that and understood and can empathize with the message. And please feel free to share it, please. I think everyone needs to give this some thought, okay? Now, I'd like to also show you here just that you can, if you go down here, you can subscribe. And it says the Prof Substack is a reader-supported publication. To receive new posts and support my work, consider becoming a free or paid subscriber. Okay, so you can become a free or paid subscriber. Also, just like the community posts on YouTube, I can put up things here, slides to look at. So there's 6 slides here informing you some more about the appellate process and about post-conviction relief. So like I said, I put Richard Allen appeal information down here. So you can check out all of this stuff. Again, that's at readtheprof.substack.com. Okay, please subscribe and enjoy it. Like I said, there'll be a lot of stuff, not just Delphi. So it's all up to you there. And that is what it is. Okay, so what else do we have here? Give me a moment. All right, so I think we're just about ready. Let's see. Got to do this. I got to do this. All right, here we go. This is Delphi, the Professionals Iii. Okay, Delphi, the Professionals Iii. This is our review of the rules of professional conduct for attorneys in Indiana. This is part 3. Okay, we are currently picking up where we left off at the rules of professional conduct, rule 4.1, under transactions with other persons or with persons other than clients. Okay. And so here we go. We're off and running. Truthfulness in statements to others. Okay. In the course of representing a client, a lawyer shall not knowingly make a false statement of material fact or law to a third person, or fail to disclose a material fact to a third person when disclosure is necessary to avoid assisting a criminal or fraudulent act by a client. unless disclosure is prohibited by Rule 1.6. A lawyer is required to be truthful when dealing with others on a client's behalf, but generally has no affirmative duty to inform an opposing party of relevant facts. A misrepresentation can occur if the lawyer incorporates or affirms a statement of another person that the lawyer knows is false. Misrepresentations can also occur by partially true but misleading statements or omissions that are equivalent of affirmative false statements. For dishonest conduct that does not amount to false statement or for misrepresentations by a lawyer other than in the course of representing a client. Statement of fact. This rule refers to statements of fact. Whether a particular statement should be regarded as one of fact can depend on the circumstances. Under generally accepted conventions in negotiation, certain types of statements ordinarily are not taken as statements of material fact. Estimates of price or value placed on the subject of a transaction and a party's intentions as to an acceptable settlement of a claim are ordinarily in this category, and so is the existence of an undisclosed principal, except where non-disclosure of the principal would constitute fraud. Lawyers should be mindful of their obligations under applicable law to avoid criminal and tortuous misrepresentation. Okay. We're going to skip the fraud. We're going to go to Rule 4.2, communication with person represented by counsel. In representing a client, a lawyer shall not communicate about the subject of the representation with a person the lawyer knows to be represented by another lawyer in the matter, unless the lawyer has the consent of the other lawyer or is authorized by a law or court order. This rule contributes to the proper functioning of the legal system by protecting a person who has chosen to be represented by a lawyer in a matter against possible overreaching by other lawyers who are participating in the matter. Interference by those lawyers with the client-lawyer relationship and the uncounseled disclosure of information relating to the representation. This rule applies to communications with any person who is represented by counsel concerning the matter to which the communication relates. This rule applies even though the represented person initiates or consents to the communication. Let's read that again. This rule applies even though the represented person initiates or consents to the communication. A lawyer must immediately terminate communication with the person if, after commencing communication, the lawyer learns that the person is one with whom communication is not permitted by this rule. And again, this is Rule 4.2. This rule does not prohibit communication with the represented person or an employee or agent of such a person concerning matters outside the representation. For example, the existence of a controversy between a government agency and a private party or between two organizations does not prohibit a lawyer from communicating with non-lawyer representatives of the other regarding a separate matter. Nor does this rule preclude communication with a represented person who is seeking advice from a lawyer who is not otherwise representing a client in the matter. A lawyer may not make a communication prohibited by this rule through the acts of another. Again, a lawyer may not make a communication prohibited by this rule through the acts of another. See Rule 8.4a. Parties to a matter may communicate directly with each other, and a lawyer is not prohibited from advising a client concerning a communication that the client is legally entitled to make. Also, a lawyer having independent justification or legal authorization for communicating with a represented person is permitted to do so. Communications authorized by law may include communications by a lawyer on behalf of a client who is exercising a constitutional or other legal right to communicate with the government. Communications authorized by law may also include investigative activities of lawyers representing governmental entities, directly or through investigative agents, prior to the commencement of criminal or civil enforcement proceedings. When communicating with the accused in a criminal matter, a government lawyer must comply with this rule. And in addition to honoring the constitutional rights of the accused, uh, the fact that a communication does not violate a state or federal constitutional right is insufficient to establish that a communication is permissible under this rule. A lawyer who is uncertain whether a communication with a represented person is permissible may seek a court order. A lawyer may also seek a court order in exceptional circumstances to authorize a communication that would otherwise be prohibited by this rule. For example, where communication with a person represented by counsel is necessary to avoid reasonably certain injury. In the case of a represented organization, this rule prohibits communications with a constituent of the organization who supervises, directs, or regularly consults with the organization's lawyer concerning the matter or has authority to obligate the organization with respect to the matter or whose act or omission in connection with the matter may be imputed to the organization for purpose of civil or criminal liability. The consent of the organization's lawyer is not required for communication with a former constituent. If a constituent of the organization is represented in the matter by his or her own counsel, the consent is by that counsel to a communication will be sufficient for the purposes of this rule. Compare Rule 3.4F. In communicating with a current or former constituent of an organization, a lawyer must not use methods of obtaining evidence that violate the legal rights of the organization. See Rule 4.4. The prohibition on communications with a represented person only applies in circumstances where the lawyer knows that the person is in fact represented in the matter to be discussed. This means that the lawyer has actual knowledge of the fact of the representation, but such actual knowledge may be inferred from the circumstances. See Rule 1.0F. Thus, the lawyers cannot evade the requirement of obtaining the consent of counsel by closing eyes to the obvious. In the event the person with whom the lawyer communicates is not known to be represented by counsel in the matter, the lawyer's communications are subject to Rule 4.3. Dealing with unrepresented persons. Just a moment. In dealing on behalf of a client with a person who is not represented by counsel, a lawyer shall not state or imply that the lawyer is disinterested. When the lawyer knows or reasonably should know that the unrepresented person misunderstands the lawyer's role in the matter, the lawyer shall make reasonable efforts to correct the misunderstanding. The lawyer shall not give legal advice to an unrepresented person other than the advice to secure counsel. If the lawyer knows or reasonably should know that the interest of such person are or have a reasonable possibility of being in conflict with the interest of the client. An unrepresented person, particularly one not experienced in dealing with legal matters, might assume that a lawyer is disinterested in loyalties or is a disinterested authority on the law, even when the lawyer represents a client. In order to avoid a misunderstanding, a lawyer will typically need to identify the lawyer's client and, where necessary, explain that the client has interests opposed to those of the unrepresented person. For misunderstandings that sometimes arise when a lawyer for an organization deals with an unrepresented constituent, see Rule 1.13d. The rule distinguishes between situations involving unrepresented persons whose interests may be adverse to those of the lawyer's client and those in which a person's interests are not in conflict with the client's. In the former situation, the possibility that the lawyer will compromise the unrepresented person's interests is so great that the rule prohibits the giving of any advice, apart from the advice to obtain counsel. Whether a lawyer is giving impermissible advice may depend on the experience and sophistication of the unrepresented person. as well as the setting in which the behavior and comments occur. This rule does not prohibit a lawyer from negotiating the terms of a transaction or settling a dispute with an unrepresented person. So long as the lawyer has explained that the lawyer represents an adverse party and is not representing the person. The lawyer may inform the person of the terms on which the lawyer's client will enter into an agreement or settle a matter. Prepare documents that require the person's signature and explain the lawyer's own view of the meaning of the document or the lawyer's view of the underlying legal obligations. Respect for the right of third persons. In representing a client, a lawyer shall not use means that have no substantial purpose other than to embarrass, delay, or burden a third person, or use methods of obtaining evidence that violates the legal rights of the person. Let me read that one again. And sorry, I'm a little distracted here. It's taking a lot to do what I'm trying to do. All right. Respect for the rights of third persons. In representing a client, a lawyer shall not use means that have no substantial purpose other than to embarrass, delay, or burden a third person, or use methods of obtaining evidence that violate the legal rights of such person. A lawyer who receives a document relating to the representation of the lawyer's client and knows or reasonably should know that the document was inadvertently sent shall promptly notify the sender. Responsibility to a client requires a lawyer to subordinate the interest of others to those of the client. But that responsibility does not imply that a lawyer may disregard the rights of third persons. It is impractical to catalog all such rights, but they include legal restrictions on methods of obtaining evidence from third persons and unwarranted intrusions into privileged relationships, such as the client-lawyer relationship. Paragraph B recognizes that lawyers sometimes receive documents that were mistakenly sent or produced by the opposing parties or their lawyers. If a lawyer knows or reasonably should know that such a document was sent inadvertently, then this rule requires the lawyer to promptly notify the sender in order to permit that the person take protective measures. Whether the lawyer is required to take additional steps, such as returning the original document, is a matter of law beyond the scope of these rules, as is the question of whether the privileged status of a document has been waived. Similarly, this rule does not address the legal duties of a lawyer who receives a document that the lawyer knows or reasonably should know may have been wrongfully obtained by the sending person. Wow, that's rich. Listen to that one again. Remember, similarly, this rule does not address the legal duties of a lawyer who receives a document that the lawyer knows or reasonably should know may have been wrongfully obtained by the sending person. For the purposes of this rule, document includes email or other electronic modes of transmission subject to being read or put into readable form. Some lawyers may choose to return a document unread, for example, when the lawyer learns before receiving the document that it was inadvertently sent to the wrong address. Where a lawyer is not required by applicable law to do so, the decision to voluntarily return such a document is a matter of professional judgment, ordinarily reserved to the lawyer. See Rules 1.2 and 1.4. Right. Law firms and associations. Responsibilities of a partner or supervisory lawyer. A partner in a law firm and a lawyer who individually or together with other lawyers possesses comparable managerial authority in a law firm shall make reasonable efforts to ensure that the firm has in effect measures giving reasonable assurance that all lawyers in the firm conform to the rules of professional conduct. A lawyer having direct supervisory authority over another lawyer shall make reasonable efforts to ensure that the other lawyer conforms to the rules of professional conduct. A lawyer shall be responsible for another lawyer's violation of the rules of professional conduct if 1. The lawyer orders or with knowledge of the specific conduct ratifies the conduct involved. 2, the lawyer is a partner, has comparable managerial authority in the law firm in which the other lawyer practices, or has direct supervisory authority over the other lawyer, and knows of the conduct at the time when its consequences can be avoided or mitigated, but fails to take reasonable remedial action. Okay, let's read that one again. Again, a lawyer shall be responsible for another lawyer's violation of the rules of professional conduct if the lawyer orders or, with knowledge of the specific conduct, ratifies the conduct involved, or the lawyer is a partner or has a comparable managerial authority in the law firm in which the other lawyer practices, or has direct supervisory authority over the other lawyer, and knows of the conduct at a time when its consequences can be avoided or mitigated, but fails to take reasonable remedial action. Yes, that is Rule 5.1. 5.1. Paragraph A applies to lawyers who have managerial authority over the professional work of a firm. See Rule 1.0c. This includes members of a partnership, the shareholders in a law firm organized as a professional corporation, and members of other associations authorized to practice law. Lawyers have comparable managerial authority in a legal services organization or a law department of an enterprise or government agency, and lawyers who have intermediate managerial responsibilities in a firm. Paragraph B applies to lawyers who have supervisory authority over the work of other lawyers in a firm. Paragraph A requires lawyers with managerial authority within a firm to make reasonable efforts to establish internal policies and procedures designed to provide reasonable assurance that all lawyers in the firm will conform to the rules of professional conduct. Such policies and procedures may include those designed to detect and resolve conflicts of interest, identify dates by which actions must be taken in pending matters, account for client funds and client funds and property, and ensure that inexperienced lawyers are properly supervised. Other measures may be required to fulfill the responsibility prescribed in paragraph A, can depend on the firm's structure and the nature of its practice. In a small firm of experienced lawyers, informal supervision and periodic review of compliance with the required systems ordinarily will suffice. In a large firm or in a practice situation, or in practice situations in which difficult ethical problems frequently arise, more elaborate measures may be necessary. Some firms, for example, have a procedure whereby junior lawyers can make confidential referral of ethical problems directly to a designated senior partner or special committee. See Rule 5.2. Firms, whether large or small, may also rely on continuing legal education and professional ethics. In any event, the ethical atmosphere of a firm can influence the conduct of all of its members. And the partners may not assume that all lawyers associated with the firm will inevitably conform to the rules. Paragraph C expresses a general principle of personal responsibility for acts of another. See also Rule 8.4a. Paragraph C2 defines the duty of a partner or other lawyer having comparable managerial authority in a law firm, as well as a lawyer who has direct supervisory authority over performance of specified legal work by another lawyer. Whether a lawyer has supervisory authority in a particular circumstance or in particular circumstances is a question of fact. Partners and lawyers with comparable authority have at least indirect responsibility for all work being done by the firm, while a partner or manager in charge of a particular matter ordinarily has supervisory responsibility for the work of other firm lawyers engaged in the matter. Appropriate remedial action by a partner or managing lawyer would depend on the immediacy of that lawyer's involvement and the seriousness of the misconduct. A supervisor is required to intervene to prevent avoidable consequences of misconduct if the supervisor knows that the misconduct occurred. Thus, if a supervising lawyer knows that a subordinate misrepresented a matter to an opposing party in negotiation, the supervisor, as well as the subordinate, has a duty to correct the misrepresentation. Professional misconduct by a lawyer under supervision could reveal a violation of paragraph B on the part of the supervisory lawyer, even though it does not entail a violation of paragraph C, because there was no direction, ratification, or knowledge of the violation. Apart from this rule and Rule 8.4a, a lawyer does not have disciplinary liability for the conduct of a partner, associate, or subordinate. Whether a lawyer may be liable civilly or criminally for another lawyer's conduct is a question of law beyond the scope of these rules. These duties, or the duties imposed by this rule on managing and supervising lawyers, do not alter the personal duty of each lawyer in a firm to abide by the rules of professional conduct. See Rule 5.2a. Responsibilities of a subordinate lawyer. A lawyer is bound by the rules of professional conduct, notwithstanding that the lawyer acted at the direction of another person. A subordinate lawyer does not violate the rules of professional conduct if that lawyer acts in accordance with the supervisory lawyer's reasonable resolution of an arguable question of professional duty. Although a lawyer is not relieved of responsibility for a violation by the fact that the lawyer acted at the direction of a supervisor, the fact may be relevant in determining whether a lawyer had the knowledge required to render conduct a violation of the rules. For example, if a subordinate filed a frivolous pleading at the direction of a supervisor, the subordinate would not be guilty of a professional violation unless the subordinate knew of the document's frivolous character. When lawyers in a supervisor-subordinate relationship encounter a matter involving professional judgment as to ethical duty, the supervisor may assume responsibility for making the judgment. Otherwise, a consistent course of action or position could not be taken. If the question can reasonably be answered only one way, the duty of both lawyers is clear, and they are equally responsible for fulfilling it. However, if the question is reasonably arguable, someone has to decide upon the course of action. That authority ordinarily reposes in the supervisor, and a subordinate may be guided accordingly. For example, if a question arises whether the interests of two clients conflict under Rule 1.7, the supervisor's reasonable resolution of the question should protect the subordinate professionally if the resolution is subsequently challenged. All right. Now we're going to get into Rule 5.3. Let's see. I'm trying to put something together for you here. Let's see. Right. So, guys, I'm starting to go here. For super chat. So please join the super chat. Um, let's do a goal of super chats. And also, while you're at it, be aware I have the support pathways like the buy me a coffee. What else we have here? It's not scrolling today, huh? What happened to my whole platform? There we go. We got the buy me a coffee and the Cash App. Buy me a coffee at the Prof's Crew and Cash App at Coffee for Prof. Okay. Also, we have our super chats. We have our subscriptions over at Substack, and also just the thumbs up and comments below. So please do join the chat. If you're lurking, it's a good time to join the chat. Be nice. Enjoy your fellow YouTubers. Okay. Uh, there are YouTube users all over who would love to speak with you. So if you're just lurking, come on in and join the conversation. As long as you're nice to each other and don't scream and yell, you're allowed to have it a free for all in the chat. Okay. And we have great mods in there who will take care of anyone who does not behave accordingly. All right. So anyway, thank you for supporting the channel in all those ways. And yeah, Let's move on here with 5.3. And my throat's starting to give me problems already. All right, y'all. So, rule 5.3. We're now at rule 5.3. Responsibilities regarding non lawyer assistance. Now, this is also an important piece here. Thank you, Amy, for sharing all my pathways there. I love you guys. Please check out all the pathways and go subscribe everywhere. And thank you for just being a wonderful community. Okay. Responsibilities regarding non lawyer assistance. So you understand, I want you all out there, put your thinking caps on and understand what this means, okay? With respect to a non lawyer employed or retained by or associated with a lawyer, that's an interesting term. Associated with. A partner and a lawyer who individually or together with other lawyers possesses comparable managerial authority in a law firm shall make reasonable efforts to ensure that the firm has in effect measures giving reasonable assurance that the person's conduct is compatible with the professional obligations of the lawyer. A lawyer having direct supervisory authority over the non lawyer shall make reasonable efforts to ensure that the person's conduct is compatible with the professional obligations of the lawyer. And a lawyer shall be responsible for the conduct of such a person that would be in violation of the rules of professional conduct if engaged in by a lawyer, if the lawyer orders or with knowledge of the specific conduct, ratifies the conduct, okay? Or the lawyer is a partner or has comparable managerial authority in the law firm in which the person is employed or has direct supervisory authority over the person and knows of the conduct at a time when its consequences can be avoided or mitigated, but fails to take reasonable remedial action. Lawyers generally employ assistants in their practice, including secretaries, investigators, law students, interns, paralegals, and other paraprofessionals. Such assistants, whether employees or independent contractors, act for the lawyer in rendition of the lawyer's professional services. A lawyer must give such assistants appropriate instruction and supervision concerning the ethical aspects of their employment, particularly regarding the obligation not to disclose information relating to the representation of the client, and should be responsible for their work product. The measures employed in supervising non-lawyers should take account of the fact that they might or may not have legal training and are not subject to professional discipline. Paragraph A requires lawyers with managerial authority within a law firm to make reasonable efforts to establish internal policies and procedures designed to provide reasonable assurance that non-lawyers in the firm will act in a compatible way or in a way compatible with the rules of professional conduct. See Rule 1 or Comment 1 to Rule 5.1. Paragraph B applies to lawyers who have supervisory authority over the work of a non-lawyer. Paragraph C specifies the circumstances in which a lawyer is responsible for conduct of a non-lawyer that would be a violation of the rules of professional conduct if engaged in by the lawyer. Okay. Rule 5.4, professional independence of a lawyer. A lawyer or firm shall not share legal fees with a non-lawyer. except that an agreement by a lawyer with the lawyer's firm, partner, or associate may provide for the payment of money over a reasonable period of time after the lawyer's death to the lawyer's estate or to one or more specified persons. A lawyer who purchases the practice of a deceased, disabled, or disappeared lawyer may, pursuant to the provisions of Rule 1.17, pay the estate or other representative of that lawyer the agreed upon purchase price. And a lawyer or law firm may include non-lawyer employees in a compensation or retirement plan, even though the plan is based in whole or in part on profit-sharing arrangements. A lawyer shall not form a partnership with a non-lawyer if any of the activities of the partnership consist of the practice of law. Sorry about that. A lawyer shall not permit a person who recommends, employs, or pays the lawyer to render legal services for another to direct or regulate the lawyer's professional judgment in rendering such legal services. A lawyer shall not practice with or in the form of a professional corporation or association authorized to practice law for a profit if the non-lawyer owns any shares, a non-lawyer owns any interest therein, except that a fiduciary representative of the estate of a lawyer may hold the stock or interest of a lawyer for a reasonable time during administration. A non-lawyer is a corporate director or officer thereof, or occupies the position of similar responsibility in any form of association other than a corporation. Or a non-lawyer has the right to direct or control the professional judgment of a lawyer. Rule 5.5, unauthorized practice of law. Okay, multi-jurisdictional practice of law. A lawyer shall not practice law in a jurisdiction in violation of the regulation of the legal profession in that jurisdiction, or assist another in doing so. A lawyer who is not admitted to practice in this jurisdiction shall not, except as authorized by these rules or other law, establish an office or other systematic and continuous presence in this jurisdiction for the practice of law, or hold out to public or otherwise represent that the lawyer is admitted to practice law in this jurisdiction. A lawyer who is not admitted to practice in this jurisdiction, but is admitted in another United States jurisdiction and is not disbarred or suspended from practice in any jurisdiction, may provide legal services on a temporary basis in this jurisdiction that are undertaken in association with a lawyer who is admitted to practice in this jurisdiction and who actively participates in the matter, are in or reasonably related to a pending or potential proceeding before a tribunal in this or another jurisdiction if the lawyer or a person the lawyer is assisting is authorized by law or order to appear in such proceeding or reasonably expects to be so authorized, are in or reasonably related to a pending or potential arbitration, mediation, or other alternative dispute resolution proceeding in this or another jurisdiction if the services arise out of or are reasonably related to the lawyer's practice in a jurisdiction in which the lawyer is admitted to practice and are not services for which the forum requires temporary admission, or are not within paragraph C2 or C3 and arise out of or are reasonably related to the lawyer's practice in a jurisdiction in which the lawyer is admitted to practice. A lawyer who is not admitted to practice in this jurisdiction but is admitted to in another United States jurisdiction or in a foreign jurisdiction and is not disbarred or suspended from practice in any jurisdiction may provide legal services in this jurisdiction if the lawyer does not establish an office or other systematic and continuous presence in this jurisdiction for the practice of law, and the legal services are provided to the lawyer's employer or its organizational affiliates and are not services for which the forum requires temporary admission. Or the services are services that the lawyer is authorized to provide by federal law or other law of this jurisdiction. Okay? We'll skip some of this commentary. As you can see, it's rather comprehensive there. It's 21 comments. So that's rule 5.5, okay? Unauthorized practice of law, multi-jurisdictional practice of law. I would recommend that you all go get a copy of this yourselves, honestly. All right, y'all. All right, all right. We're checking out the restrictions on a right to practice. Okay. A lawyer shall not participate in offering or making a partnership, shareholder, operating, employment, or other similar type of agreement that restricts the rights of a lawyer to practice after termination of the relationship, except an agreement concerning benefits upon retirement. An agreement in which a restriction on the lawyer's right to practice is part of the settlement of a client controversy. Responsibilities regarding law-related services. A lawyer shall be subject to the rules of professional conduct with respect to the provision of law-related services. As defined in paragraph B, if the law-related services are provided, one, by the lawyer in circumstances that are not distinct from the lawyer's provision of legal services to clients, or two, in other circumstance, by an entity controlled by the lawyer individually or with others, if the lawyer fails to take reasonable measures to assure that a person obtaining the law-related services knows that the services are not legal services and that the protections of the client-lawyer relationship do not exist. Okay? Hmm. The term law-related services denotes services that might reasonably be performed in conjunction with and in substance are related to the provision of legal services that are not prohibited as unauthorized practice of law when provided by a non-lawyer. When a lawyer performs law-related services or controls an organization that does so or uses a law license to promote an organization or otherwise creates a basis for a belief that the client may be dealing with an attorney, such as where a person uses JD on his business cards or stationery or hangs framed law degrees or court admissions on office walls, there exists the potential for ethical problems. Principal among these is the possibility that the person for whom the law-related services are performed fails to understand that the services may not carry with them the protections normally afforded as part of the client-lawyer relationship. The recipient of the law-related services may expect, for example, that the protection of client confidences, prohibitions against representation of purposes of persons with conflicting interests, and obligations of a lawyer to maintain professional independence apply to the provision of law-related services when they may not be the case, or that may not be the case. Rule 5.7 applies to the provision of law-related services by a lawyer, even when the lawyer does not provide any legal services to the person for whom the law-related services are performed, and whether the law-related services are performed through a law firm or a separate entity. The rule identifies the circumstances in which all of the rules of professional conduct apply to the provision of law-related services. Even when those circumstances do not exist, however, the conduct of a lawyer involved in the provision of law-related services is subject to those rules that apply generally to lawyer conduct, regardless of whether the conduct involves the provision of legal services. See, for example, Rule 8.4. When law-related services are provided by a lawyer under circumstances that are not distinct from the lawyer's provision of legal services to clients, a lawyer in providing the law-related services must adhere to the requirements of the rules of professional conduct as provided in paragraph A1. Even when the law-related and legal services are provided in circumstances that are distinct from each other, for example, through separate entities or different support staff within the law firm, the rules of professional conduct apply to the lawyer as provided in paragraph A2, unless the lawyer takes reasonable measures to assure that the recipient of the law-related services knows that the services are not legal services and that the protections of the client-lawyer relationship do not apply. Law-related services may also be provided through an entity that is distinct from that through which the lawyer provides legal services. If the lawyer individually or with others has control of such an entity's operations, the rule requires the lawyer to take reasonable measures to assure that each person using the services of the entity knows that the services provided by the entity are not legal services and that the rules of professional conduct that relate to the client-lawyer relationship do not apply. A lawyer's control of an entity extends to the ability to direct its operation. Whether a lawyer has such control will depend on the circumstances of the particular case. When a client-lawyer relationship exists with a person who is referred by a lawyer to a separate law-related service entity controlled by the lawyer, individually or with others, the lawyers must comply with Rule 1.8a. In taking reasonable measures referred to in paragraph A2, to assure that a person using law-related services understands the practical effect or significance of the inapplicability of the rules of professional conduct, the lawyer should communicate to the person receiving the law-related services in a manner sufficient to assure that the person understands the significance of the fact. That's important. That the relationship of the person to the business entity will not be a client-lawyer relationship. The communication should be made before entering into an agreement for provision or providing law-related services, and preferably should be in writing. The burden is upon the lawyer to show that the lawyer has taken reasonable measures under the circumstances to communicate the desired understanding. For instance, a sophisticated user of law-related services, such as a publicly held corporation, may require a lesser explanation than someone unaccustomed to making distinctions between legal services and law-related services, such as an individual seeking tax advice from a lawyer, accountant, or investigative services in connection with a lawsuit. Regardless of the sophistication of potential recipients of law-related services, a lawyer should take special care to keep separate the provision of law-related and legal services in order to minimize the risk that the recipient will assume that the law-related services are legal services. The risk of such confusion is especially acute when the lawyer renders both types of services with respect to the same matter. Under some circumstances, the legal and law-related services may be so closely entwined that they cannot be distinguished from each other, and the requirement of disclosure and consultation imposed by paragraph A2 of the rule cannot be met. In such a case, a lawyer will be responsible for assuring that both the lawyer's conduct and, to the extent required by Rule 5.3, that of a non-lawyer employees in the distinct entity that the lawyer controls complies in all respects with the rules of professional conduct. A broad range of economic and other interests of clients may be served by lawyers engaging in the delivery of law-related services. Examples of law-related services include providing title insurance, financial planning, accounting, real estate counseling, legislative lobbying, economic analysis, social work, psychological counseling, tax preparation, and medical or environmental consulting. When a lawyer is obliged to accord the recipients of such services the protections of those rules that apply to the client-lawyer relationship, the lawyer must take special care to heed the prescriptions of the rules addressing conflict of interest, Rules 1.7 through 1.11, especially Rules 1.7a2 and 1.8 a, b, and f, and to scrupulously adhere to the requirements of Rule 1.6 relating to disclosure of confidential information. Where the provision of law-related services is subject to these rules, the promotion of law-related services must also, in all respects, comply with Rules 7.2 through 7.5, dealing with advertising and solicitation. In that regard, lawyers should take special care to identify the obligations that may be imposed as a result of a jurisdiction's decisional law. When the full protections of all of the Indiana rules of professional conduct do not apply to the provision of law-related services, principles of law external to the rules, for example, the law of principal and agent, govern the legal duties owed to those receiving services. Those other legal principles may establish a different degree of protection for the recipient with respect to confidentiality of information, conflicts of interest, and permissible business in relationship with clients. See also Rule 8.4, Misconduct. All right, yo. All right, just want to thank everybody who's sending a super chat and the and the cash apps. I mean, appreciate you. If you've come over to subscribe to Substack, I can't speak. Too much reading. Too much damn reading. I can't even speak. All right, so can't speak. Too much reading, but please go subscribe to Substack. Let me post it again for you. Go subscribe over there, and uh, and thank you for all of those who are supporting the channel. Okay, we're now on to public service. Okay, Rule 6.1, pro bono. Okay, pro bono public service. Just a moment. I'm out of chocolate when I need the chocolate. Well, I need something. Another coffee? Okay. A lawyer should render public interest legal service. A lawyer may discharge this responsibly by providing professional services at no fee or at a reduced fee to persons of limited means, or to public service or charitable organizations or groups by service and activities for improving the law. The legal system or the legal profession, and by financial support for organizations that provide legal services to persons of limited means. The American Bar Association House of Delegates has formally acknowledged the basic responsibility of each lawyer engaged in the practice of law to provide public interest legal services without fee or at a substantially reduced fee in one or more of the following areas: poverty law, civil rights law, public rights law, charitable organization representation, and the administration of justice. The Indiana State Bar Association's House of Delegates has declared that, quote, all Indiana lawyers have an ethical and social obligation to provide uncompensated legal assistance to poor persons, close quotation, and adopted an aspirational goal of 50 hours a year, or an equivalent financial contribution, for each member of the bar. For purposes of this paragraph, poverty law means legal representation of a client who does not have the financial resources to compensate counsel. Civil rights, including civil liberties law, means legal representation involving a right of an individual that society has special interest in protecting. Public rights law means legal representation involving an important right belonging to a significant segment of the public. Charitable organization representation means legal services to or representation of charitable, religious, civic, governmental, and educational institutions in matters in furtherance of the organization's purpose, where the payment of customary legal fees would significantly deplete the organization's economic resources or where it would be inappropriate. Okay. Administration of justice means activity, whether under bar association auspices or otherwise, which is designated to increase, or sorry, designed to increase the availability of legal representation or otherwise improve the administration of justice. This may include increasing the availability of legal resources to individuals or groups, improving the judicial system, or reforming legal institutions that significantly affect the lives of disadvantaged individuals and groups. The rights and responsibilities of individuals and organizations in the United States are increasingly defined in legal terms. As a consequence, legal assistance in coping with the web of statutes, rules, and regulations is imperative for persons of modest and limited means, as well as for the relatively well-to-do. The basic responsibility for providing legal services for those unable to pay ultimately rests upon the individual lawyer, and personal involvement in the problems of the disadvantaged can be one of the most rewarding experiences in the life of a lawyer. Every lawyer, regardless of professional prominence or professional workload, should find time to participate in or otherwise support the provision of legal services to the disadvantaged. The provision of free legal services to those unable to pay reasonable fees continues to be an obligation of each lawyer as well as the profession generally. But efforts of individual lawyers are often not enough to meet the need. Thus, it has been necessary for the profession and government to institute additional programs to provide legal services. Accordingly, legal aid offices, lawyer referral services, and other related programs have been developed, and others will be developed by the profession and government. Every lawyer should support all proper efforts to meet this need for legal services. Typically, to fulfill the aspirational goals in Comment 1, legal services should be performed without the expectation of compensation. If during the course of a representation, a paying client is no longer able to afford a lawyer's legal services, and the lawyer continues to represent the client at no charge, any work performed with the knowledge and intent of no compensation may be considered pro bono legal service. The award of attorney's fees in a case originally accepted as pro bono does not disqualify such services from fulfilling the foregoing aspirational goals. However, the lawyers who continue or who receive attorney fees in pro bono cases are strongly encouraged to contribute an appropriate portion of such fees to organizations or projects that benefit persons of limited means or that promote access to justice for persons of limited means. Typically, the following would not fulfill aspirational goals in Comment 1. Legal services written off as bad debts, legal services performed for family members, legal services performed for political organizations for election purposes, and activities that do not involve the provision of legal services, such as serving on the board of a charitable organization. Accepting appointments. A lawyer shall not seek to avoid appointment by a tribunal to represent a person except for good cause, such as when representing the client is likely to result in violation of the rules of professional conduct or other law, representing the client is likely to result in an unreasonable financial burden on the lawyer, or the client or the cause is so repugnant to the lawyer as to be likely to impair the client-lawyer relationship or the lawyer's ability to represent the client. Membership in legal service organization. A lawyer may serve as director, officer, or member of a legal services organization apart from the law firm in which the lawyer practices, notwithstanding that the organization serves persons having interests adverse to the client of the lawyer. The lawyer shall not knowingly participate in the decision or action of the organization if participating in the decision or action would be incompatible with the lawyer's obligations to a client under Rule 1.7, or where the decision or action could have a material adverse effect on the representation of a client of the organization whose interests are adverse to the client of the lawyer. Law reform activities affecting client interests. A lawyer may serve as a director, officer, or member of an organization involved in a reform of law or its administration, notwithstanding that the reform may affect the interests of a client of the lawyer. When the lawyer knows that the interest of a client may be materially benefited by a decision in which the lawyer participates, the lawyer shall disclose that fact, but need not identify the client. Nonprofit and court-annexed limited legal services programs. A lawyer who, under the auspices of a program sponsored by a nonprofit organization or court, provides short-term limited legal services to a client without expectation by either the lawyer or the client that the lawyer will provide continuing representation in the matter, is subject to rules 1.7 and 1.9a only if the lawyer knows that the representation of the client involves a conflict of interest, and is subject to rule 1.10 only if the lawyer knows that another lawyer associated with the lawyer in a law firm is disqualified by Rule 1.7 or 1.9a with respect to the matter, except as provided in paragraph A2, Rule 1.10 is inapplicable to the representation governed by this rule. All right, I'll rule I'm sorry, what am I talking about? One. There we go. Rule 6.7, requirement for reporting of direct pro bono legal services. Reporting requirement. To encourage and assess the current and future extent of volunteer legal services provided directly to individuals' limited means and to public service or charitable groups or organizations, an attorney must report, as part of an attorney's annual registration, the following information. Pro bono hours, no compensation. During the previous calendar year ending December 31st, I have personally provided approximately blank hours of legal services in Indiana or other states directly to individuals reasonably believed to be of of limited means, without charge and without any fee expectation when the services were rendered. During the previous calendar year ending December 31st, I have personally provided approximately blank hours of legal services in Indiana or other states directly to public service or charitable groups or organizations as defined by Rule 6.1, Comment 1D, without charge and without any fee expectation when the services were rendered. Pro bono hours, substantially reduced compensation. During the previous calendar year ending December 31st, I have personally provided approximately blank hours of legal services directly to individuals reasonably believed to be of limited means at a charge of less than 50% of my normal rate and without expectation of any greater fee when the services were rendered. B. During the previous calendar year ending December 31st, I have personally provided approximately blank hours of legal services directly to public service or charitable groups, organizations as defined by Rules 6.1, Comment 1D of less than 50% of my normal rate, and without expectation of any greater fee when the services were rendered. Financial contribution. During the previous calendar year ending December 31st, I have either made monetary contributions of blank dollars to one or more of the following: Indiana Bar Foundation, IRC 501c3 Bar Foundation in Indiana, which provides financial support to qualifying legal service organization or low pro bono district. Any IRC 501c3 pro bono district listed in the Indiana Supreme Court website, or a legal service organization located in Indiana that is eligible for fee waiver under IC 333732B or 2 made an in-kind contribution of tangible property fairly valued at blank dollars to one or more of the foregoing qualifying legal service organizations or local pro bono districts. Exempt persons. An attorney is exempt from reporting under this rule, who is exempt from the provision of pro bono legal services because he or she is currently serving as a member of the judiciary or judicial staff, is a government lawyer prohibited by statute, rule, or regulation or agency policy from providing legal services outside his or her employment, or is retired from the practice of law or maintains inactive standing with the executive director of the Indiana Office of Admissions and Continuing Education. Reporting required. By requiring the affirmative reporting of pro bono legal services provided directly to an individual of limited means, this Rule 6.7 requires reporting for only for a subset of the public interest legal service encouraged under Rule 6.1. Public disclosure of information received. Information received pursuant to this rule is declared confidential and shall not be publicly disclosed by the Indiana Supreme Court or any of its agencies on an individual or firm-wide basis. 7.1 Information about legal services. Communications concerning a lawyer's services. A lawyer shall not make a false or misleading communication about the lawyer or the lawyer's services. A communication is false or misleading if it contains a material misrepresentation of fact or law, or omits a fact necessary to make the statement considered as a whole not materially misleading. This rule governs all communications about a lawyer's services, including advertising permitted by Rule 7.2. Whatever means are used to make known a lawyer's services, statements about them must be truthful. Truthful statements that are misleading are also prohibited by this rule, in absence of special circumstances that serve to protect the probable targets of a communication from being misled or deceived. A communication will violate Rule 7.1 if it 1. Is intended or is likely to result in a legal action or a legal position being asserted merely to harass or maliciously injure another. Contains statistical data or other information based on past performance or an express or implied prediction of future success. Contains a claim about a lawyer made by a third party that the lawyer could not personally make consistent with the requirements of this rule. Appeals primarily to a layperson's fear, greed, or desire for revenge. Compares the services provided by the lawyer or a law firm with the other lawyer's services unless the comparison can be factually substantiated. Contains any reference to results obtained that may reasonably create an expectation of similar results in future matters. Contains a dramatization or recreation of events unless the advertising clearly and conspicuously discloses that a dramatization or recreation is being presented. Contains a representation, testimonial, or endorsement of a lawyer or other statement that, in light of all the circumstances, is intended or is likely to create an unjustified expectation about a lawyer or law firm or a person's legal rights. States or implies that a lawyer is a certified or recognized specialist other than is permitted by Rule 7.4. is prohibited by Rule 7.3. See also Rule 8.4E for the prohibition against stating or implying an ability to influence improperly a government agency or official to achieve results by means that violate the rules of professional conduct or other law. Advertising. Subject to the requirements of this rule, lawyers and law firms may advertise their professional services and law-related services. The term advertise, as used in these Indiana rules of professional conduct, refers to any manner of public communication, partly or entirely intended or expected to promote the purchase of or use of the professional services of a lawyer, law firm, or any employee of either involving the practice of law or law-related services. The lawyer shall not give anything of value to a person for recommending or advertising the lawyer's services, except that a lawyer may pay the reasonable cost of the advertisement or communications permitted by this rule, pay the usual charges of a legal service plan or not-for-profit or qualified lawyer referral service plan described by this rule. 7.3D, pay for a law practice in accordance with Rule 1.17 and refer clients to another lawyer or non-lawyer professional pursuant to an agreement not otherwise prohibited under these rules that provides for the other person to refer clients or customers to the lawyer if the reciprocal referral agreement is not exclusive and the client is informed of the existence and nature of the agreement. Any communication subject to this rule shall include the name and office address of at least one lawyer or law firm responsible for its content. The lawyer or law firm responsible for the content of any communication subject to this rule shall keep a copy or recording of each such communication for 6 years after its dissemination. To assist the public in obtaining legal services, lawyers should be allowed to make known their services, not only through reputation, but also through organized information campaigns in the form of advertising. Advertising involves an active quest for clients, contrary to the tradition that a lawyer should not seek clientele. However, the public's need to know about legal services can be fulfilled in part through advertising. Provided that the advertising otherwise complies with the requirements of the rules of professional conduct, permissible subjects of advertising include name and contact information, including name and contact information for an attorney, a law firm, and professional associates, one or more fields of law in which the lawyer or any law firm practices using commonly accepted and understood definitions and designations, date and place of birth, date and place of admission to the bar of state and federal courts, schools attended with dates of graduation, degrees, and other scholastic distinctions, academic, public, or quasi-public military or professional positions held, military service, legal authorship, legal teaching position, memberships, offices, and committee assignments in bar, professional, scientific, or technical associations or societies, memberships in offices in legal fraternities and legal societies, technical and professional licenses, memberships in scientific, technical, and professional associations and societies, foreign language ability, names and addresses of bank references, professional liability insurance coverage, prepaid or group legal services programs in which the lawyer participates is allowed by Rule 7.3. Whether credit cards or other credit arrangements are accepted, office and telephone, answering service hours, and fees charged and other terms of service pursuant to which an attorney is willing to provide legal or law-related services. Neither this rule nor Rule 7.3 prohibits communications authorized by law, such as notice to members of class in a class action litigation. Lawyers are not permitted to pay others for channeling professional work. Paragraph B1, however, allows a lawyer to pay for advertising and communications permitted by this rule, including the cost of print directory listings, online directory listings, newspaper ads, television and radio airtime, domain name registrations, sponsorship fees, banner ads, and group advertising. A lawyer may compensate employees, agents, and vendors who are engaged in to provide marketing or client development services such as publicists, public relations personnel, business development staff, and website designers. See Rule 5.3 for the duties of lawyers and law firms with respect to the conduct of non-lawyers who prepare marketing materials for them. Right, let me get a drink of water, please. All right, guys. Apologize to spill. I was really thirsty. Um, Please go ahead and for those of you who have not subscribed to Substack, please go check out the Substack. Please check out the Buy Me a Coffee and the Cash App, and also look down below. I have a goal set up. I'm trying to get 20 super chats tonight. 20 super chats. Um, so please support the channel if you'd like to. Um, I'm going to continue reading, and my mouth is dry, so sorry I had to get some gum, get some water. That's what's up. All right. Here we go. Direct contact with prospective clients. Rule 7.3. A lawyer, including the lawyer's employer agent, shall not, by in person, live telephone, or real time electronic contact, solicit professional employment from a prospective client when a significant motive for the lawyer doing so is the lawyer's pecuniary gain, unless the person contacted is a lawyer, has family, close personal or prior professional relationship with the lawyer, and a lawyer shall not solicit professional employment from a prospective client by in-person or by written, recorded, audio, video, or electronic communication, including the internet, if the prospective client has made known to the lawyer a desire not to be solicited by the lawyer. The solicitation involves coercion, duress, or harassment. The solicitation concerns an action for personal injury or wrongful death or otherwise relates to an accident or disaster involving the person to whom the solicitation is addressed or a relative of that person, unless the accident or disaster occurred more than 30 days prior to the initiation of the solicitation. The solicitation concerns a specific matter and the lawyer knows or reasonably should know that the person to whom the solicitation is directed is represented by a lawyer in the matter. The lawyer knows or reasonably should know that the physical, emotional, or mental state of the person makes it unlikely that the person would exercise reasonable judgment in employing a lawyer. Every written, recorded, or electronic communication from a lawyer soliciting professional employment from a prospective client potentially in need of legal services in a particular matter shall include the words advertising material, conspicuously placed on both the face of any outside envelope and at the beginning of any written communication, and both at the beginning and ending of any recorded or electronic communication, unless the recipient of the communication is a person specified in paragraphs A1 or A2. A copy of each such communication shall be filed with the Indiana Supreme Court Disciplinary Commission at or prior to its dissemination to the prospective client. A filing fee in the amount of $50 payable to the Supreme Court Disciplinary Commission Fund shall accompany each such filing. In the event that a written, recorded, or electronic communication is distributed to multiple prospective clients, a single copy of the mailing list information specific to the intended recipients, such as name, address, including email address, and date of mailing, may be filed with the Commission. Each time any such communication is changed or altered, a copy of the new or modified communication shall be filed with the Disciplinary Commission at or prior to the time of its mailing or distribution. The lawyer shall retain a list containing the names and addresses, including email addresses, of all persons or entities to whom each communication has been mailed or distributed for a period of not less than 1 year following the last date of mailing or distribution. Communications filed pursuant to the subdivision shall be open to public inspection. Hmm, that's interesting. All right, we're moving on to D. A lawyer shall not accept referrals from, make referrals to, or solicit clients on behalf of any lawyer, referral service, unless such service falls within the clauses 1 to 4 below. A lawyer or any other lawyer affiliated with the lawyer or the lawyer's firm may be recommended, employed, or paid by or cooperate with one of the following offices or organizations that promote the use of the lawyer's services or those in the lawyer's firm if there's no interference with the exercise of independent professional judgment on behalf of a client of the lawyer or the lawyer's firm. Hey, a legal office or public defender office operated or sponsored on a not-for-profit basis by a law school accredited by the American Bar Association section on legal education and admissions to the bar. Operated or sponsored on a not-for-profit basis by a bona fide non-profit community organization. Operated or sponsored on a not-for-profit basis by a governmental agency. Operated, sponsored, or approved in writing by the Indiana State Bar Association, the Indiana Trial Lawyers Association, the Defense Trial Council of Indiana, any bona fide county or city bar association within the state of Indiana, or any other bar association whose lawyer referral service has been sanctioned for operation in Indiana by the Indiana Disciplinary Commission and operated by a circuit or superior court within the state of Indiana. A military legal assistance office A lawyer referral service operated, sponsored, or approved by an organization listed in Clause 1D or any other nonprofit organization that recommends, furnishes, or pays for legal services to its members or beneficiaries, but only if the following conditions are met. The primary purposes of such organization do not include the rendition of legal services. The recommending, furnishing, or paying for legal services to its members is incidental and reasonably related to the primary purposes of such organization. Such organization does not derive a financial benefit from the rendition of legal services by the lawyer, and the member or beneficiary for whom the legal services are rendered, and not such organization, is recognized as the client of the lawyer in the matter. A lawyer shall not compensate or give anything of value to a person or organization to recommend or secure the lawyer's employment by a client, or as a reward for having made a recommendation resulting in the lawyer's employment by a client, except that the lawyer may pay for public communication permitted by Rule 7.2, and the usual and reasonable fees and dues charged by the lawyer referral service falling within the provisions of paragraph D above. A lawyer shall not accept employment when the lawyer knows or reasonably should know that the person who seeks the lawyer's services does so as a result of lawyer conduct prohibited under this rule, 7.3. Commentary. There is potential for abuse inherent in direct in-person, live telephone, or real-time electronic contact by a lawyer. With a prospective client known to need legal services. These forms of contact between a lawyer and a prospective client subject the layperson to the private importuning of the trained advocate in a direct interpersonal encounter. The prospective client, who may already feel overwhelmed by the circumstances giving rise to the need for legal services, may find it difficult fully to evaluate all available alternatives with reasoned judgment and appropriate self-interest in the face of the lawyer's presence and insistence upon being retained immediately. The situation is fraught with the possibility of undue influence, intimidation, and overreaching. This potential for abuse inherent in direct in-person live telephone or real-time electronic solicitation of prospective clients justifies its prohibition, particularly since the lawyer advertising and written and recorded communications permitted under 7.2 offer alternative means of conveying necessary information to those who may be in need of legal services. The use of general advertising and written and recorded or electronic communications to transmit information from lawyer to prospective client rather than direct in-person, live telephone, or real-time electronic contact will help to assure that the information flows cleanly as well as freely. The contents of advertisements and communications permitted under Rule 7.2 can be permanently recorded so that they cannot be disputed and may be shared with others who know the lawyer. This potential for informal review is itself likely to help guard against statements and claims that might constitute false and misleading communications in violation of Rule 7.1. The contents of direct, in-person, live telephone, or real-time electronic conversations between a lawyer and a prospective client can be disputed and may not be subject to third-party scrutiny. Consequently, they are much more likely to approach and occasionally cross the dividing line between accurate representations and those that are false and misleading. There's far less likelihood that a lawyer would engage in abusive practices against an individual who is a former client or with whom the lawyer has close personal or family relationships, or in situations in which the lawyer is motivated by considerations other than the lawyer's pecuniary gain. nor is there a serious potential for abuse when the person contacted is a lawyer. Consequently, the general prohibition in Rule 7.3a and the requirements of Rule 7.3c are not applicable in those situations. Also, paragraph A is not intended to prohibit a lawyer from participating in constitutionally protected activities of public or charitable legal service organizations or bona fide political, social, civic, fraternal, employee, or trade organizations whose purposes include providing or recommending legal services to its members or beneficiaries. But even permitted forms of solicitation can be abused. Thus, any solicitation which contains information which is false or misleading within the meaning of Rule 7.1, which involves coercion, duress, or harassment within the meaning of Rule 7.3b2, or which involves contact with a prospective client who has made known to the lawyer a desire not to be solicited by the lawyer within the meaning of Rule 7.3b1, is prohibited. Moreover, if after sending a letter or other communication to a client as permitted by Rule 7.2, the lawyer receives no response, any further effort to communicate with the prospective client may violate the provisions of Rule 7.3b. This rule allows targeted solicitation of potential plaintiffs or claimants in personal injury and wrongful death causes of action or other causes of action that relate to an accident, disaster, death, or injury, but only if such solicitation is initiated no less than 30 days after the incident. This restriction is reasonably required by the sensitized state of the potential clients, who may be either injured or grieving over the loss of a family member, and the abuses that experience has shown exist in this type of solicitation. Rule 7.4, communication of fields of practice and specialization. A lawyer may communicate the fact that the lawyer does or does not practice in a particular field of law. A lawyer admitted to engage in patent practice before the United States Patent and Trademark Office may use the designation patent attorney or a substantially similar designation. A lawyer engaged in admiralty practice may use the designation admiralty, proctor in admiralty, or a substantially similar designation. A lawyer shall not state or imply that the lawyer is a specialist in a particular field of law unless the lawyer has been certified as a specialist by an independent certifying organization accredited by the Indiana Commission for Continuing Legal Education pursuant to Admission and Discipline Rule 30, and the certifying organization is identified in the communication. Pursuant to rulemaking powers inherent in its ability and authority to police and regulate the practice of law by attorneys admitted to the practice of law in the state of Indiana, the Indiana Supreme Court hereby vests exclusive authority for accreditation of independent certifying organizations that certify specialists in legal practice areas and fields in the Indiana Commission for Continuing Legal Education. The Commission shall be the exclusive accrediting body in Indiana for the purposes of Rule 7.4d1 above, and shall promulgate rules and guidelines for accrediting independent certifying organizations that certify specialists in legal practice areas and fields. The rules and guidelines shall include requirements of practice experience, continuing legal education, objective examination, and peer review and evaluation, with the purpose of providing assurance to the consumers of legal services that the attorneys attaining certification within areas of specialization have demonstrated extraordinary proficiency within those areas of specialization. The Supreme Court shall retain review oversight with respect to the Commission, its requirements, and its rules and guidelines. The Supreme Court retains the power to alter or amend such requirements, rules, and guidelines, and to review the actions of the Commission in respect to this Rule 7.4. Okay? Whoop. There we go. Rule 7.5, firm names and letterheads. A lawyer shall not use a firm name, letterhead, or other professional designation that violates Rule 7.1. A trade name may be used by a lawyer in private practice if it does not imply a connection with a government agency or with public or charitable legal services organization and is not otherwise in violation of Rule 7.1. A law firm with with offices in more than one jurisdiction may use the same name or other professional designation in Indiana if the name or other designation does not violate paragraph A, and the identification of the lawyers in an office of the firm indicates the jurisdictional limitations on those not licensed to practice in Indiana. The name of a lawyer holding a public office shall not be used in the name of a law firm or in communications on its behalf during any substantial period in which the lawyer is not actively and regularly practicing within the firm. A member of a part-time legislative body, such as the General Assembly, a county or city council, or school board, is not subject to this rule. Lawyers may state or imply that they practice in a partnership or other organization only when they in fact do so. All right. All right, we're going over to maintaining the integrity of the profession, which is Rule 8.1. Okay, we're going into Rules 8.1 through 8.5. Rule 8.1, Bar Admission and Disciplinary Matters. An applicant for admission to the bar or lawyer in connection with a bar admission application or in connection with a disciplinary matter shall not knowingly make a false statement of material fact or fail to disclose a fact necessary to correct a misapprehension known by the person to have arisen in the matter, or knowingly fail to respond to a lawful demand for information from an admissions or disciplinary authority, except that this rule does not require the disclosure of information otherwise protected by Rule 1.6. The duty imposed by this rule extends to persons seeking admission to the bar as well as to lawyers. Hence, if a person makes a material false statement in connection with an application for admission, it may be the basis for subsequent disciplinary action if the person is admitted, and in any event may be relevant in a subsequent admission application. The duty imposed by this rule applies to a lawyer's own admission or discipline as well as that of others. Thus, it is a separate professional offense for a lawyer to knowingly make a misrepresentation or omission in connection with the disciplinary investigation of the lawyer's own conduct. Paragraph B of this rule also requires correction of any prior misstatement in the matter that the applicant or lawyer may have made, an affirmative clarification of any misunderstanding on the part of the admissions or disciplinary authority of which the person involved becomes aware. This rule is subject to the provisions of the Fifth Amendment of the United States Constitution and corresponding provisions of state constitutions. A person relying on such a provision in response to a question, however, should do so openly and not use the right of non-disclosure as a justification for failure to comply with this rule. If a lawyer representing an applicant for admission to the bar or representing a lawyer who is the subject of a disciplinary inquiry or proceeding is governed by the rules applicable to the client-lawyer relationship, including Rule 1.6 and in some cases Rule 3.3. Judicial and legal officials. A lawyer shall not make a statement that the lawyer knows to be false or with reckless disregard as to its truth or falsity concerning the qualifications or integrity of a judge, adjudicatory officer or public legal officer, or of a candidate for an election or appointment to judicial or legal office. A lawyer who is a candidate for judicial office shall comply with the applicable provisions of the Code of Judicial Conduct. Assessments by lawyers are relied on in evaluating the professional or personal fitness of persons being considered for election or appointment to judicial office and to public legal offices, such as Attorney General, Prosecuting Attorney, and Public Defender. Expressing honest and candid opinions on such matters contributes to improving the administration of justice. Conversely, false statements by a lawyer can unfairly undermine public confidence in the administration of justice. When a lawyer seeks judicial office, the lawyer should be bound by applicable limitations on political activity. To maintain the fair and independent administration of justice, lawyers are encouraged to continue traditional efforts to defend judges and courts unjustly criticized. Rule 8.3, reporting professional misconduct. A lawyer who knows that another lawyer has committed a violation of the rules of professional conduct that raises a substantial question as to that lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects shall inform the appropriate professional authority. A lawyer who knows that a judge has committed a violation of applicable rules of judicial conduct that raises a substantial question as to the judge's fitness for office shall inform the appropriate authority. This rule does not require reporting of a violation or disclosure of information if such action would involve disclosure of information that is otherwise protected by Rule 1.6 or is gained by a lawyer by providing advisory opinions or telephone advice on legal ethics issues as a member of a bar association committee or similar entity formed for the purposes of providing such opinions or advice or designated by the Indiana Supreme Court. The relationship between lawyers or judges acting on behalf of a judge or lawyers assistance program approved by the Supreme Court and lawyers or judges who have agreed to seek assistance from and participate in any such programs shall be considered one of attorney and client, with its attendant duty of confidentiality and privilege from disclosure. Self-regulation of the legal profession requires that members of the profession initiate disciplinary investigation when they know of a violation of the rules of professional conduct. See? Lawyers have a similar obligation with respect to judicial misconduct. An apparently isolated violation may indicate a pattern of misconduct that only a disciplinary investigation can uncover. An apparently isolated violation may indicate a pattern of misconduct that only a disciplinary investigation can uncover. Reporting a violation is especially important where the victim is unlikely to discover the offense. A report about misconduct is not required where it would involve a violation of Rule 1.6. However, a lawyer should encourage a client to consent to disclosure where prosecution would not substantially prejudice the client's interests. If a lawyer were to oblige to report every violation of the rules, the failure to report any violation would itself be a professional offense. Such a requirement existed in many jurisdictions but proved to be unenforceable. This rule limits the reporting obligation to those offenders that a self-regulating professional or profession must vigorously endeavor to prevent. A measure of judgment is therefore required in complying with the provisions of this rule. The term substantial refers to the seriousness of the possible offense and not the quantum of evidence of which the lawyer is aware. A report should be made to the bar disciplinary agency unless some other agency, such as a peer review agency, is more appropriate in the circumstances. Similar considerations apply to the reporting of judicial misconduct. The duty to report professional misconduct does not apply to a lawyer retained to represent a lawyer whose professional conduct is in question. Such a situation is governed by the rules applicable to the client-lawyer relationship. Information about a lawyer or judge's misconduct or fitness may be received by a lawyer in the course of that lawyer's participation in an approved lawyer's or judge's assistance program. In that circumstance, providing for an exception to the reporting requirements of paragraphs A and B of this rule encourages lawyers and judges to seek treatment through such a program. Conversely, without such an exception, lawyers and judges may hesitate to seek assistance from these programs, which may then result in additional harm to their professional careers and additional injury to the welfare of clients and the public. These rules do not otherwise address the confidentiality of information received by a lawyer or judge in participating in an approved lawyer's assistance program. Such an obligation, however, may be imposed by the rules of the program or other law. Okay. All right. All right. Thanks, everybody, for being here. We're going to move into the final portion here. We are getting closer to wrapping this up. Okay. We are, let me pull this down a minute. We are ever so close to wrapping this up. And boy, it's been a long one. I think this has been maybe an 8-hour endeavor totally. But it's no wonder why people don't read these basic rules for professionals, i.e., lawyers in Indiana. It's a wonder they won't read it because it's just too much. But anyway, I'm glad that we have gone through this because uh, we're just reaching the final stretch. Okay, and while we're here, I just want to ask everyone to uh, remember that we have all various places we do things. Right, I'm on Twitter. I have the two YouTube channels, Prof and the Prof True Crime, big channel, little channel. And now we have the new Substack that I'm going to share again, that I'm going to be working a lot on. Just heads up to you guys. Be working a lot over there at Substack. And, um, and also, we have our current little uh, fundraising goal of 20 super chats. So I want to thank everyone who contributed. It looks like we got 6. And then we also, I think it's actually 8 because I think that we had a couple memberships renewed that for some reason didn't get clicked into the little goal. So we have actually 8 so far. But anyway, please join the little party there and support the channel. And wow, we we're almost there. Okay, we're almost there. We're at the finish line here. This is very interesting, though. Okay, Rule 8.4: misconduct. It is professional misconduct for a lawyer to violate or attempt to violate the rules of professional conduct, to knowingly assist or induce another to do so, or do so through the acts of another. Um, commit a criminal act that reflects adversely on the lawyer's honesty, trustworthiness, or fitness as a lawyer, or in other respects. Engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. Engage in conduct, engage in conduct that is prejudicial to the administration of justice. State or imply an ability to influence or improperly a government agency or official or to achieve results by means that violate the rules of professional conduct or other law. To knowingly assist a judge or judicial officer in conduct that is in violation of applicable rules of judicial conduct or other law. To engage in conduct in a professional capacity, manifesting by words or conduct bias or prejudice based upon race, gender, religion, national origin, disability, sexual orientation, age, socioeconomic status, or similar factors. Legitimate advocacy respecting the foregoing factors does not violate this subsection. A trial judge's finding that preemptory challenges were exercised on a discriminatory basis does not alone establish a violation of this rule. Lawyers are subject to discipline when they violate or attempt to violate the rules of professional conduct. Knowingly assist or induce another to do so through the acts of another, as when they request or instruct an agent to do so on the lawyer's behalf. Paragraph A, however, does not prohibit a lawyer from advising a client concerning the action or concerning action the client is legally entitled to take. Again, rules of professional conduct subject lawyers to discipline when they knowingly assist or induce another to do so, or do so through the acts of another, as when they request or instruct an agent to do so on a lawyer's behalf. Many kinds of illegal conduct reflect adversely on fitness to practice law, such as offenses involving fraud and the offenses of willful failure to file an income tax return. However, some kinds of offenses carry no such implication. Traditionally, the distinction was drawn in terms of offenses involving moral turpitude. That concept can be concluded as construed. I'm getting tired here. Construed to include offenses concerning some matters of personal morality, such as adultery and comparable offenses, that have no specific connection to the fitness for practice of law. Although a lawyer is personally answerable to the entire criminal law, a lawyer should be professionally answerable only for offenses that indicate lack of those characteristics relevant to practice law. Offenses involving violence, dishonesty, breach of trust, or serious interference with the administration of justice are in that category. A pattern of repeated offenses, even ones of minor significance, when considered separately, can indicate indifference to legal obligation. A lawyer may refuse to comply with an obligation imposed by the law upon good faith belief that no valid obligation exists. The provisions of Rule 1.2d concerning a good faith challenge to the validity, scope, meaning, or application of the law apply to challenges of legal regulation of the practice of law. Lawyers holding a public office assume legal responsibilities going beyond those of other citizens. A lawyer's abuse of public office can suggest an inability to fulfill the professional role of lawyers. The same is true of abuse of positions of private trust, such as trustee, executor, administrator, guardian, agent, and officer, director, or manager of a corporation or other organization. Disciplinary authority, choice of law. Disciplinary authority. A lawyer admitted to practice in this jurisdiction is subject to the disciplinary authority of this jurisdiction, regardless of where the lawyer's conduct occurs. A lawyer not admitted in this jurisdiction is also subject to the disciplinary authority of this jurisdiction if the lawyer provides or offers to provide any legal services in this jurisdiction. A lawyer may be subject to the disciplinary authority of both this jurisdiction and another jurisdiction for the same conduct. Choice of law. In any exercise of the disciplinary authority of this jurisdiction, the rules of professional conduct to be applied shall be as follows. For the conduct in connection with a matter pending before a tribunal, the rules of jurisdiction in which the tribunal sits unless the rules of the tribunal provide otherwise, and for any other conduct, the rules of the jurisdiction in which the lawyer's conduct occurred. Or if the predominant effect of the conduct is in a different jurisdiction, the rules of that jurisdiction shall be applied to this conduct. It is a long-standing law that the conduct of a lawyer admitted to practice in this jurisdiction is subject to the disciplinary authority of this jurisdiction. Extension of this disciplinary authority of this jurisdiction to other lawyers who provide or offer to provide legal services in this jurisdiction is for the protection of the citizens of this jurisdiction. Reciprocal enforcement of a jurisdiction's disciplinary findings and sanctions will further advance the purposes of this rule. A lawyer who is subject to the disciplinary authority of this jurisdiction under Rule 8.5a appoints an official to be designated by this court to receive service of process in this jurisdiction. The fact that a lawyer is subject to this disciplinary authority of this disciplinary jurisdiction of this jurisdiction may be a factor in determining whether personal jurisdiction may be asserted over the lawyer for civil matters. Blah, blah, blah. My speech is failing. A lawyer may potentially be subject to more than one set of rules of professional conduct, which impose different obligations. The lawyer may be practiced to licensed to practice in more than one jurisdiction with differing rules, or may be admitted to practice before a particular court with rules that differ from those of the jurisdiction or jurisdictions in which the lawyer is licensed to practice. Additionally, the lawyer's conduct may involve significant contacts with more than one jurisdiction. Paragraph B seeks to resolve such potential conflicts. Its premise is that minimizing conflicts between rules, as well as uncertainty about which rules are applicable, is in the best interest of both clients and the profession, as well as the bodies having authority to regulate the profession. Accordingly, it takes the approach of 1, providing that any particular conduct of a lawyer shall be subject to only one set of rules of professional conduct, and 2, making the determination of which set of rules applies to particular conduct as straightforward as possible, consistent with the recognition of appropriate regulatory interest of relevant jurisdictions. Paragraph B1 provides that as to a lawyer's conduct relating to a proceeding pending before a tribunal, the lawyer shall be subject only to the rules of the jurisdiction in which the tribunal sits, unless the rules of the tribunal, including its choice of law rule, provide otherwise. As to all other conduct, including conduct in anticipation of proceeding not yet pending before a tribunal, paragraph B2 provides that a lawyer shall be subject to the rules of the jurisdiction in which the lawyer's conduct occurred, or if the predominant effect of the conduct is in another jurisdiction, the rules of that jurisdiction shall be applied to the conduct. In the case of conduct in anticipation of a proceeding that is likely to be before a tribunal, the predominant effect of such conduct could be where the conduct occurred, where the tribunal sits, or in another jurisdiction. If 2 admitting jurisdictions were to proceed against a lawyer for the same conduct, they should, applying this rule, identify the same governing ethics rules. They should take all appropriate steps to see that they do not apply the same rule, or that they do apply, They should take all appropriate steps to see that they do apply the same rule to the same conduct, and in all events should avoid proceeding against a lawyer on the basis of 2 inconsistent rules. The choice of law provision applies to lawyers engaged in transnational practice, unless international law, treaties, or other agreements between competent regulatory authorities in the affected jurisdictions provide otherwise. Use of non-lawyer assistance. Introduction. Subject to the provisions in Rule 5.3, all lawyers may use non-lawyer assistance in accordance with the following guidelines. A non-lawyer assistant shall perform services only under the direct supervision of a lawyer authorized to practice in the state of Indiana. Independent non-lawyer assistants are prohibited from establishing a direct relationship with a client and to provide legal services. A lawyer is responsible for all of the professional actions of a non-lawyer assistant performing services at the lawyer's direction and should take reasonable measures to ensure that the non-lawyer assistant's conduct is consistent with the lawyer's obligations under the rules of professional conduct. Again, a lawyer is responsible for all of the professional actions of a non-lawyer assistant performing services at the lawyer's direction and should take reasonable measures to ensure that the non-lawyer assistant's conduct is consistent with the lawyer's obligations under the rules of professional conduct. Permissible delegation. Provided the lawyer maintains responsibility for the work product, a lawyer may delegate to a non-lawyer assistant or paralegal any task normally performed by the lawyer. However, any task prohibited by statute, court rule, administrative rule, or regulation, controlling authority, or the Indiana rules of professional conduct may not be assigned to a non-lawyer. Say it again for those in the back. Provided the lawyer maintains responsibility for the work product, a lawyer may delegate to a non-lawyer assistant or paralegal any task normally performed by the lawyer. However, any task prohibited by statute, court rule, administrative rule, regulation, controlling authority, or the rules of professional conduct may not be assigned to a non-lawyer. Prohibited delegation. A lawyer may not delegate a non-lawyer assistant responsibility for establishing an attorney-client relationship, responsibility for establishing the amount of a fee to be charged for a legal service, or responsibility for a legal opinion rendered to a client. Guideline 9.4, duty to inform. It is the lawyer's responsibility to take reasonable measures to ensure that clients, courts, and other lawyers are aware that a non-lawyer assistant whose services are utilized by the lawyer in performing legal services is not licensed to practice law. Identification on letterhead. A lawyer may identify non-lawyer assistants by name and title on the lawyer's letterhead and on business cards identifying the lawyer's firm. Client confidences. It is a responsibility of a lawyer to take reasonable measures to ensure that all client confidences are preserved by non-lawyer assistants. Once again, guideline 9.6. For those in the back, sorry, yes. Guideline 9.6, client confidences. It is a responsibility of a lawyer to take reasonable measures to ensure that all client confidences are preserved by non-lawyer assistants. All client confidences. It is the lawyer's responsibility to take reasonable measures to ensure that all client confidences are preserved by non-lawyer assistants. Charge for services. A lawyer may charge for the work performed by the non-lawyer assistants. A lawyer may not split legal fees with a non-lawyer assistant, nor pay a non-lawyer assistant for the referral of legal business. A lawyer may compensate a non-lawyer assistant based on the quantity and quality of the non-lawyer assistant's work and the value of that work to a law practice, but the non-lawyer assistant's compensation may not be contingent by advance agreement upon the profitability of the lawyer's practice. Continuing legal education. A lawyer who employs a non-lawyer assistant should facilitate the non-lawyer assistant's participation in appropriate continuing education and pro bono publico activities. Legal assistant ethics, guideline 9.10. Okay, 9.10. The apex of the pyramid here. All lawyers who employ non-lawyer assistants in the state of Indiana shall assure that such non-lawyer assistants conform their conduct to be consistent with the following ethical standards. A non-lawyer assistant may perform any task delegated and supervised by a lawyer so long as the lawyer is responsible to the client and maintains a direct relationship with the client and assumes full professional responsibility for the work product. A non-lawyer assistant shall not engage in the unauthorized practice of law. A non-lawyer assistant shall serve the public interest by contributing to the delivery of quality legal services and the improvement of the legal system. A non-lawyer assistant shall achieve and maintain a high level of competence, as well as a high level of personal and professional integrity and conduct. A non-lawyer assistant's title shall be fully disclosed in all business and professional communications. A non-lawyer assistant shall preserve all confidential information provided by the client or acquired from other sources before, during, and after the course of professional relationship. Once again, number F for the people in the back. A non-lawyer assistant, okay, shall preserve all confidential information provided by the client or acquired from other sources like discovery before, during, and after the course of the professional relationship. A non-lawyer assistant shall avoid conflicts of interest and shall disclose any possible conflict to the employer or client, as well as to the prospective employers or clients. Let's talk about that again. Once again, I'm preaching to the people in the back. A non-lawyer assistant shall avoid conflicts of interest and shall disclose any possible conflict to the employer or client, as well as to the prospective employer or client. A non-lawyer assistant shall act within the bounds of law uncompromisingly for the benefit of the client. A non-lawyer assistant shall do all things incidental, necessary, or expedient for the attainment of the ethics and responsibilities imposed by the statute or rule of court. A non-lawyer assistant shall be governed by the Indiana Rules of Professional Conduct. That's what we're reading. A non-lawyer assistant shall be governed by the Indiana Rules of Professional Conduct. For the purposes of this guideline, a non-lawyer assistant includes but shall not be limited to paralegals, legal assistants, investigators, law students, and paraprofessionals. And that, ladies and gentlemen, is a capstone of our Indiana Rules of Professional Conduct. I think you should get to know these rules like the back of your hand, especially this third episode that we've covered. In my opinion, this installment here covered the most important aspects of the rules of the professional conduct, and probably worth a rewatch. I know that I'm going to be doing a bunch of looking at this or rewatching of this and looking at these particular rules that we've covered tonight. Um, like I said, this has been many, many hours to go through this, but this being the most important episode, and it'll be probably the shortest, I think it's an important one because let me go back and look what we've done. We've done Professionals 1 was 3 hours, 18 minutes. Professionals 2 was 2 hours, 37 minutes. And this one is approaching the 3 hour mark. So they're all not that bad. I would say that we're looking at 8 to 9 hours in totality. And that's quite a bit. It's 150 pages. No, it's at 170. I think 170 pages. Not too bad. A lot of commentary. And what I like about the commentary is the commentary further elaborates and illustrates the particulars of each rule. So as we go through this, it's interesting to see how the commentary expands on the particular rules that give us the most concern. Um, anyway, that's for you guys. So my throat is just about done, and I'm gonna decide to call it because it's been rather long, and I'm still not fully recovered. To be most honest with you, I'm halfway there. Uh, but I do want to take this time to thank my closest. Okay, and those of you who I've spoken with, if I say my closest, I mean all of you who I've literally had phone calls with in this past week. I just want to thank you. These phone calls have just gotten better and better, and I have learned more and more, and I've been inspired to do better, to be better, and to do more and be more. And it's all thanks to my friends who the back and forth has been extremely positive, and I think we're all in a good place right now, and so we're all exchanging really productive ideas, and it's really a wonderful thing. I mean, I could not ask for such good advice and people to consult with, and so those who know who they are, I want to send them out a thanks because, boy, it's just been a really wonderful week, and a lot of good ideas have gone by. And it's only Thursday, okay? So what I'm going to do tonight is save my voice, save the rest of my voice for tomorrow night's show, hoping that we'll have a tomorrow night show and a Friday night show. And I'll ask all of you who happen to be on the replay, if you are, go ahead and leave comments down below in the replay. I always appreciate the comments. I truly do. And also, please go check the community page where I post updates. Go subscribe to the backup channel to get me up to 5,000. Let's get me to 5,000 at the backup channel. So go subscribe to the backup channel. Go to the Substack. You can find in the description and also in the About Me of the YouTube page all the wonderful contact pathways. I have email if you want to email me. I've got the Substack if you want to go and discuss with me over there about things that I care about. Um, and I've got the subscription services and whatnot. I've also got the little merchandise that some people appreciate, the little T-shirts and all the various things over there. There's bags and there's coffee cups. I want to buy myself a coffee mug. I just keep forgetting, honestly. Every time I say I need the coffee mug, I forget to when I'm off the stream. But I need to go get me a Prof coffee mug so I can show it on the channel. Okay, so I'm ready for my Prof coffee mug. But thanks everyone for being here. I know I'm not going to do much talking with the chat because my throat's fried. But thank you so much for being in the chat. I appreciate so much that you were all there interacting and discussing. I'll be discussing with you soon. Hopefully tomorrow I'll feel better, and hopefully next week and month I'll feel even better because I'm already getting there. Anyway, special shout out to my main mod Amy. And guys, another thing. Remember a month or two ago, I asked you all to email me if you were interested in helping out behind the scenes with some things. So everyone who I've asked to email me, some of you we haven't really been getting on the ball yet, but trust me, I want to get on the ball. Okay, so I don't want to call your names out, but you know who you are. So if you get an email from me in the next, few days, uh, it's because I'm ready to do some talking about what we talked about. So if I asked you to email me and you did, I'll be emailing you back again this weekend. So it's going to be like that. Okay. Um, anyway, thank you for everyone for being here. So look, as far as my supporters tonight, let me get them on stage real quick. Thank them again. It's a new day. Not only she become a member for the ninth month. Thank you. It's a new day. She hit up that $5 holler. Thank you for all you do and endure, Prof. Then Diana said, "Let's do this." Amy jumped in, said, "Let's do this." Rebecca said, "Nice job on your blog, Prof." And Diana said, "It's easier to win than a spelling bee." Nicole Watts said hello. Tracy Fleetwood said for the chocolate, and I will be getting that tomorrow. Tomorrow's my chocolate run. Gonna do my chocolate run. So, y'all keeping up with me? Who wants to go to the grocery store? Can we go buy some chocolate? All right. So that's what up with that. Anyway, big shout out to Rick Snay. I had a nice talk with him, and I see he's been doing positive things. So shout out to Rick. Shout out to Diana. Um, Rebecca Ann, It's a New Day. Anyone who has a YouTube channel, shout out to all of you with your YouTubes. Good luck on your YouTubes. Keep it going. Also, Muty Silence. Muty Silence has a YouTube channel, so make sure you go subscribe to everybody who got the YouTube channels in the chat. And yeah, hopefully I'll see you tomorrow. All right. That's what it is. It is what it is. And I'll see y'all later. So appreciate everyone being here. And I'm gonna get out of here and go take care of my throat again because yeah, I figured it would be a rough one tonight. But hey, we're through it. And it's very important. Very important stuff. So don't forget how important it is. It's important. Rules of professional conduct, I mean, they apply. They do apply. So get to know them. And also go read that Substack. If you do nothing else, go read the community page or the Substack. You'll appreciate it. Okay. God bless. Good night. God bless Libby and Abby. And hide your kids, hide your wife.